Hi, welcome to this edition of Conversation. Today I'm discussing about family court. Um, a lot of you have heard about family court, and I'm sure lots of persons are asking what's family court about and all that. Is it a court where people go to marry and all that and all that? So I have brought a lawyer of many years' experience. I've seen her a number of times at the family court, and she has assisted a lot of people at the family court to settle their grievances in that court. And I have decided to bring her on board so that we can just talk informally, discuss as much as we can to share knowledge and share ideas about what goes on in the family court. She's a graduate of law from the University of Benin, and her name is Austin-Modo Chitto, Barrister Mrs. Austin-Modo Chitto. Barrister, you're welcome to the show.
Thank you very much, Ekamini. I'm good with Austin.
Oh, yeah.
I'm good with that.
Good
Just
with
Austin or
Okay.
CH.
And you know, lots of people
My
here know
Lord
you.
Justice Winifred used to call me CH, and I'm good with that.
And you know, lots of lawyers here, they know you as Austin-Modo.
Yes. They
So-
really do not know my first name,
Yeah, yeah.
and I'm good with that. It feels
It's interesting.
like a brand.
Okay.
Austin-Modo is a
Austin-Modo.
brand.
Yeah.
A legal brand.
Yeah. It's actually a very unique name. I heard it for the first time a number of years back. And you've done law practice here for some time.
This is my ninth year. By
Your
next year I'll
ninth
be
year.
10.
Wow. This is
In Akwa Ibom.
This is interesting.
And to say, Akwa Ibom, thank you.
This is interesting. So, like I said at the intro, lots of people don't know much about family courts. And that's why I said, let us have this conversation so that we can enlighten people as much as we can about family court. So, put us in the know. What's family court about?
Basically, family court is all about children.
Okay.
Basically,
Okay.
issues that concerns the children.
The welfare of children.
Yes. Their liabilities, their assets,
Okay.
and everything that is done in family court is in the paramount interest of the children, not the parents. Not the parents. And that is one area we are feeling as lawyers.
Yeah.
Yes, we come to champion the interest of parties, whoever we are representing, forgetting that there are children there. And that court is exclusively for them. Exclusively for them. For them and nothing else. So we discuss their liabilities, we discuss their assets.
Yeah.
And that asset is not like they bought by their money. No. It is the assets and liabilities of their parents. That is what we use in deciding their paramount interest.
Okay. Wow, this is interesting. Because I'm sure lots of persons were thinking that, okay, if I have a family problem, I can take it to the family court. But like you have rightly streamlined, it's a court that deals more primarily with the welfare and interest of the children. So now, at what point does the welfare of the child go to the family court? Is it when the parents are still together, or mostly when the parents, are no more together, they're separated, and therefore, So at what point?
At the point when parents are separated,
Okay.
that's where the welfare of the children become contested. It is only that. But sometimes, like I have a case pending where parties are still living together.
Okay.
You understand? But then the man is docile. The man abdicated from his duties.
Okay.
So the woman is saying, I can't be in this marriage where I still want to be married to you, but I can't bear the whole responsibility on my own. I think I need something to compel you to contribute, no matter how small. Even if you give me 10,000 every month, even if you just pay half of the children's school fees, I don't mind. But I need something, a force, to do that. You can still come to family court to do that.
Okay.
Though it's rare.
Yeah, it's rare.
It's very rare.
Yeah.
But when you come to family court, if you champion your cause and discuss it and argue it properly, the court will see need, because it's not for the interest of either party. It's just for the children.
Okay.
But generally, it's when parties are separated and they come to court. Sometimes, like my Justice Hinton used to say, the learned JCA now, they say the child right law is the only law that acknowledges immorality. Why did you say so? Parties might not be married.
Okay.
They might just have a one-night stand and somebody gets pregnant.
Okay.
And there's a child. Family court entertains that. You don't want to ask whether you're legally married or not. That's why he said this child right law is the only law that acknowledges immorality. And I think I share same opinion with him.
Yeah, because no matter how the child,
as long as there is a child, no matter the circumstances wherein that child came from,
he needs to be cared for.
He needs to be cared. He or she needs to be cared for.
Okay, so where the husband and the wife are no more together, and maybe one of them wishes to go to the family court to make a complaint to compel the other one to also contribute to the welfare of the child, how does a person commence that process? One,
you engage a lawyer.
Okay.
If you want to. Sometimes they go to organizations.
Okay.
Sometimes they go to the women affairs. Sometimes they run to FIDA.
Okay.
So FIDA will now ask a lawyer or engage a lawyer, one of their members, to help out.
Okay. And what's FIDA?
Understand? Sorry?
What's FIDA?
The National Federation of Female Lawyers.
Okay.
They've championed a lot of that cause. That's their basic responsibility.
Yeah.
To ensure that these women and children are properly taken care of.
Okay.
Yes.
Okay.
So if you go to them, then if they don't go to them, they come to individual lawyers, private practitioners. But sometimes some parties just file a suit on their own.
They go to court straight?
Yes.
Even when they are not lawyers?
Yes.
Well, that's interesting that the family court accepts such filing.
Yes.
Because in the regular court, it would be required that you get the lawyer to file your processes for you. So it's interesting to know that in the family court, that means the procedure in the family court is simplified.
Very simplified, very informal.
Okay.
Where we don't encourage objections, preliminary objections, motion on 5 different motions, motion to vary court order, motion
for injunction and all that.
It's not encouraged.
In the family court?
Yes, it is not encouraged.
Wow,
and that is why I like what Justice Daniel Nsemeke is doing now.
Yeah.
If you find motion to vary his order, he'll tell you, I will take it at the end of judgment, by our judgment.
Yeah.
So you see, it frustrates that. So we just face why we are there.
Okay.
We are not there. We are there just for the interest of the case. Because when you file motion for to vary, you waste the time. And at the end of the day, who suffers?
It's a child.
It's a child, and that is why we are in court. The child right law says the paramount interest, whatever. And one beautiful thing about family court is that the judges have unlimited powers.
Okay.
Because they use their discretion to say in the paramount interest of the children. So what is paramount to them, and they use their discretion. So it is their discretion that matters most. If they decide that we want to take the case from you, they will take and put in any home.
But before taking the kid from any of the parties, is it possible that the judges will give the parties an opportunity to say their own part?
Very well. Fair hearing is upheld to the letter in family courts. And that's why you see a lawyer going, and the next 1 hour they are not out. Because emotions are involved in this.
Yeah.
Some parties are aggrieved. Most people that come to family court are distressed people. So you have to hear them. And when you hear a party and you don't hear the other party, it is not justice. Yeah. And when they go out there, they feel burdened, they feel pained. Yeah. Some of them will say, they don't even let me talk for court.
And that's not good.
And it's not good for the public. Justice is a 3-way thing.
Yeah.
To the courts, to the parties,
yeah,
and to the people out there, society out there.
That's true. So, because everybody that comes to family court also has family members that are interested in the matter, church members, and members of their associations and all that.
That's why lawyers should be patient when they come to family courts.
That's it.
I've had issues with lawyers who say, Modo, you spend 3 hours just to do one matter. Yes. Because when we had to look, the court had to look at all the contending matters.
It's about the real interest of the child.
All I know is that for parties to get to family court, they are both guilty. That's my opinion, and that's my position anyway. parties
Because
are guilty.
if party A was doing the right thing, party B is also doing the right thing, there will be no need coming to the family court. The interest of the children would have been
taken care of.
So let me also ask, what are the likely orders that family courts will make, regarding the interest of the children? What are the examples of orders, that the family court would make?
One, first and foremost, custody.
Okay.
Primary custody has to be ordered where the child resides. Should the child reside with party A or party B, either the mother or the father. When that is decided, we'll now talk of who takes care of the responsibilities.
Okay.
The custodian parent, the non-custodian parents will contribute to the child's welfare. And mostly what I have seen so far from experience, the men are being ordered to pay school fees. You understand? They pay school fees, they contribute a token for child support, yes.
Okay.
So basically, it's in rare occasion that they are asked to provide for accommodation. Very rare.
Okay.
Very exceptional circumstances.
Okay.
Which was approved.
Are there factors that determine the decision of the court on who takes care, who custodies the child? For instance, is there any particular age that a child should be for the court to say, okay, you have to be with your father or you have to live with your mother? Are there these considerations in deciding who takes custody of the child from time to time?
Child rights law defines a child to be 1 to 16 years.
Okay.
The child rights law wasn't specific on who takes custody.
Okay.
But we have decided cases like the Okafor and Okafor, where the judge said that tender children are better with their mothers. Okay. Because naturally, mothers know how to take care of kids. Yes. So that's it. So no specific age.
Okay.
But then by decided cases, tender children should be. And when we look at its prevalence, it's very obvious.
That's true.
That we mothers or the women know how to take care of these children more.
Okay.
They show more passion. They are sometimes fathers forget the children in school. The mom will remember and rush down. So, but there is no specific age.
Okay. So, but what are the considerations? What are the reasons that would make the court to make an order for even tender children to be with their father instead of being with their mother?
One primary thing is the conduct
of the mother.
The conduct of the mother. When the mother's conduct is very reprehensive. When you have, let me tell you something. For a woman can be adulterous but a good mother. For the fact that a mother is adulterous does not disqualify her from having custody of the children.
Wow.
Yes. You can be an adulterous wife, but a good mother. We have cases to prove to that. But when you have, adultery is not criminal. But when a woman has criminal tendencies, smokes, into drugs, very aggressive, have anger issues. Some of them commit their suicidal. You understand? Those things. In such situation, the courts will be compelled to give custody to the father. And sometimes the child rights law says in whatever decision the court wants to take, the child wishes should be considered.
Okay.
And it's very key. I lost a case recently because the children who live with their mother told the court that we want to be with our father.
Wow. So there are instances that the children are allowed to
No, the children are interviewed. So it is the duty of the lawyer to make that application. My Lord, we want the children to be interviewed. And if the children decide that I want to be with party A, so be it. The judge hands are tied. No matter whether it's their father, you cannot do otherwise. Because you have gone foul of the provision of the child rights law.
Yes. Before tender children will come and say, my Lord, I want to be with my father or I want to be with my mother, They have reason.
They have reasons. Like in this case that I lost, before one of the judges, the children live with their mom in another state. But look at their reasons. One, they said, when we were in Akwa Ibom, we used to go to a school where they call us by our native name. One. While we were in this state, we used to attend church. And where we are now, we don't attend church.
Wow.
And the judge gave us her ruling. You understand? So the wishes of the children is very
important.
Very important.
Well, this is very interesting, and I'm sure you've learned one or two things about this conversation. Imagine that piece of information there, that even while considering the welfare of the children, judges can call for the children to come to the court, and then the judges will ask them questions, and whatever they say is very significant in determining,
It's significant.
It's
a decisive factor.
Well, who takes custody of the children. One other thing I want to ask is this. Do you think that there is something that needs to be done to enlighten people the more? Do you think that lots of people understand the workings of the family court, including lawyers also in general practice?
We lawyers will understand the working of the family court. But our nature, we are paid to come and argue and come and defend our client. The family court, with all due respect, is not where you come and show your expertise.
Your legal prowess and all that.
No, it's not where you come and show your expertise in the law. Because like I tell people, blood flows in family courts.
That's true.
And when you disrupt the flow of that blood, it bounces back to you. And you know what that means. I will leave it at that. But lawyers come because they want to defend, they want to present themselves to their client as we are doing our job. They come and distort facts. And that's why they fight. I have done a matter with a lawyer who filed motion to vary a court order for his client to pay 10,000 for 3 children.
Wow.
Was that necessary?
The court had ordered for something higher.
The court had ordered for 15,000. He asked the court to vary to 10,000.
For 3 children?
For 3 children. The court varied to 10,000. He still filed appeal.
Wow.
So in essence, he doesn't want the father of the children to be responsible for the children. Why he's being paid? Lawyers should retrace their steps.
Yeah.
Lawyers in that category should retrace their steps.
Yeah.
We have lawyers that had encouraged their clients to flout the orders of court. We have lawyers that had encouraged their clients to come to courts and misinform the courts. Lawyers that are in such category should retrace their steps. They can do it in other courts.
Yeah,
with
but
all
not
due
family
respect.
court.
They're not in family court.
Because like you rightly said, family
children
court
are
is about
suffering.
children. It's not a place to come and do too much of
Not too much of quoting of laws,
Yeah.
show how your knowledge of you are very in tune with the laws, you can cite it. No. Those children do not understand
That's
section
true.
1, section 2,
That's
or that
true.
that's all they understand is that my school fees has been paid.
That's true.
Daddy sent money, or mommy sent money for my feeding.
That's true.
But in all, we've had reasons to interview children. They say, we want our parents to be together. That's the mindset of those. They want their parents to be together. They do not understand the intricacies of this separation we are talking about.
Yeah. So from your experience in the family court, like I rightly said, I've seen you a number of times there. And I must appreciate you for what you do for the parties in the family court. I've seen you represent women. I've also seen you represent men. And ultimately, you represent the children in all these cases. But let me ask, who are the most guilty parties between men and women that causes the bringing of cases to the family court? Are men more guilty or are women more guilty?
Like I said earlier, as long as they are in family court, parties are guilty.
Both parties.
Parties are guilty. And that's why you have to be fair to both of them. I'm fair to both parties, irrespective of who I'm representing. And I've had reason, some of my clients had reason to take their files because I have told them to their face that, no, you are wrong. You are wrong. Your conduct is bad. For the fact that you had issues with your husband and you are in court does not make you come to court and begin to, some of them, we see them, they abuse the men in court. I don't know how, I'm just trying to restrain myself from saying certain things. But then, parties are guilty. All I beg of lawyers, when you come, remember that the children are involved at the middle of all, and just be fair. Let us encourage them to see if they could come together and live under the same roof as husband and wife. If they could resolve I want to thank God for all the judges in family court. We've been able to resolve a lot of family marital issues that these parties go back and live as one. So they are all guilty.
So it now takes me to the issue of confidentiality, because the regular court, everything is said in the open and anybody in the court hears what is being said. I am sure that there are some persons that would want some confidentiality about their family matters and all that. So give us a picture. Is a family court the same as the regular court that everybody can hear what goes on, or is there any room for confidentiality in the family court?
There is room for confidentiality in family courts. When I came to Akwa Ibom and I started appearing in family courts, we used to appear in the judge's chamber, just counsel and parties. But after COVID, a lot of things changed. We started appearing in the open courts. But then, the judges used to make it open. If you want your matter to be heard in chambers, please bring it to the fore. You make the application, and your matter is heard in the chambers. Then when the children are invited, there are no two ways about it.
Okay.
It must be heard in chambers. Then now, what judges do if it comes to pre-hearing, it is done in chambers. Because that pre-hearing is when the details of what transpired between parties that generated and brought them to court is being heard. So it's always in the judges' chambers. Okay. When at that point, that is where they can resolve. If they cannot resolve and they cannot even agree on terms, then come to the open. You just adopt your pleadings.
Okay.
Yes.
Okay. Now it's interesting to know that there is that confidentiality, so that nobody becomes afraid of his matter being heard by another. And like Barrister Mrs. Austin-Modo has said, it's about the interest of the children, the welfare of the children. It's not a place to go and do so much of advocacy as we do in election petition matters, objection, my lord, and all that, but just a place to assist the parties to see how the children can be, well taken care of. So let me have your final shot on this. What generally is your advice to parties out there who have issues that they want to take to the family courts, those that are already in the family courts, and everybody generally?
One is, I want them to disabuse their mind, because some persons come to court with the mind that one party is fully responsible for everything. There is no law that supports that. The party will pay school fees, the party will contribute to feeding, to the children's support, the party will provide accommodation, the party will do a lot of disabuse their minds from that. When you come to family courts, responsibilities are shared. Then one party feels it's their prerogative to have custody. It's not so. There are indices, there are grounds wherein the courts will order custody. And one of the major is conduct of parties. They now look at the financial capabilities of the party. Then I want to talk to lawyers when they come to family courts. It is not where we show our logo that we can argue, advocacy is no. We should consider both parties and remember, let us have it at the back of our minds that children are involved. And when homes are all broken, this degenerates to bad governments. to every other thing that is not working well in society. So let our focus when we come to family court is to see how this couple can go back together and live as man and wife again. So that's why I always, and I still stand by it, I advise my gender. If there is no battery in the marriage, stay and take care of your kids. If there is no battery in that marriage, stay and take care of the family. Because over time, there is God in heaven who will over time turn your everything around for your good. Yeah. Because God will see your heart and will make things better for you. But if there is battery, please run. If there is battery, please run. Again, another way we could be helped in family courts is if the chief judge or the government could help with, like sometimes a party flouts the orders of court. Yeah. And there is need, and the court will cite that party for contempt. Like I said earlier, most people that come to family court, they are already distressed people. Yeah. Sometimes when you go to the police, who are supposed to assist in this arrest, they ask them to bring 15,000, 20. The amount are far too much for them. You find out that because they cannot pay that money, that party that has flouted the orders of court, nothing happens to that party because they cannot execute the order of court. And the court cannot execute the order himself.
They have to pass through the police.
They must. So if the police, I think the family court, some police should be attached to family court to help to enforce and execute these orders of court. Particularly when the court has the powers to compel a party to appear before it. When such orders are made, the police attached to that court should be able to help execute that. Then sometimes some persons some civil servants flout the orders. They refuse to pay the maintenance allowance. There is no need going after them.
You deduct from their salaries.
But even when the court makes that order, it's very difficult. The rigors of getting that to be done is much. So the court should be able to have a forum where those head of parastatals in the ministry should be talked with, so that when such application comes to them, they should not make us go from one office to the other, go and see this body, go and do that. Once they are there, they'll see it. They should just enforce it. Thank you.
Well, this is very interesting. I must thank you for coming to share.
My honor.
Because you see, the knowledge that you have from family court is not something that money can buy. Yeah. It is the experience. And experience you don't buy. It is something that you do every day. And I must commend you for sharing your knowledge with us today. Many thanks.
And I want to add, family courts built my marriage.
Oh, that's good.
Yes.
That's
one beautiful thing that family court did to me personally.
Yeah.
It helped to build my marriage.
Yeah, because from what you see
from
every
what
day,
I was seeing in
advise,
court, or I saw in family court.
Yeah. You just say no.
I advised myself.
Exactly. But let me before we just leave, that means for those that want to dissolve their marriages, it is not the family court
No,
they
family
should go
court
to.
doesn't have jurisdiction.
It doesn't have jurisdiction. Those that want to dissolve, they have to go to the regular court.
They have to go to
the
the
family court is strictly for the welfare.
Even the
of
magistrate court does not have powers to grant custody of children children in a marriage that is protected by the Act.
Okay. No. It's only the family court that has that power.
No, they have family courts.
Okay.
Magistrate court division.
Okay.
They have high courts.
Yeah.
But for the magistrate, when a marriage is under the Act, the children of that marriage, they cannot grant custody, they cannot entertain the custody issues.
Okay. Oh, thank you so much once again for sharing your ideas with us. And I do hope that you have learned one or two things about this conversation. This conversation is for you, it's for your friends, it's for all the persons that are close to you. We pray that family court will not have matters again, if it is possible, so that everybody will just take care of children. Children came, they never elected to come, but they came through the meeting of the male and the female, and therefore, whatever the disagreements, children must be well taken care of. Many thanks always. for your time.